Sheila bought a second-hand car from Mina for 15,000 ringgit. She was not aware that the car was jointly owned by Mina and her husband, Tommy. With Tommy's permission, Mina was put in possession of the car. Even though Sheila has paid for the full price, Mina could not deliver the car as she was prevented by Tommy from doing so. Advise Sheila on her rights against Mina. The issue is to determine whether Sheila has any right upon the car that she purchased from Mina but prevented from delivered by Tommy, joint owner of the car.
Today, we continue to our law. What is the goods? Goods mean under the section 2 set of Good Act 1957. This means the every description of movable property except to actionable claims and monies. Then also to the includes the stock and shares, crops and grass, and thing to attach to the land if agreed to be served before sale or under the contract of sale. And also, by virtue of the definition, land is excluded from the meaning of goods under the Sale of Goods Act. Okay, we talk about the contract of sale. Contract of sale meaning the by the section 4 subsection 1 is meaning the agreement where the seller transfer or agree to transfer ownership of good to buyer. Transfer must be for a price, and also in other words, the sale occur when the ownership or property in good passes to the buyer. And also the transfer of title based on the general rule. According to the section 27 of Sale of Good Act, this means that if the seller is not owner of doesn't have the authority, there is no valid title. This means that the if goods are sold by a person who is not the owner and is not the authorized by the owner, the buyer does not acquire a better title than the seller had unless the real owner through his conduct is prevented from denying the seller's authority to sell. And also, the Section 27 reflected the English law principle known as nemo dat quod non habet. This means that the no one can give what he does not have. And simply put, if the someone buy the goods from a seller who is not the rightful owner and the buyer doesn't have the permission to sell, the buyer does not give the valid ownership. The purpose of this rule is to protect the right of the true owner. Without the rule, the true owner interest in the goods, for example, if the stolen, could be unfairly affected. And also we discussed our case Lim Julai and Zeno 1964 is the case the respondent purchased the material for the construction project and they had to deliver to the site. Later they found the material has been sold by Ahmad to the appellant for the 40,000 ringgit, of the which Ahmad received 7,000 ringgit as the part payment. The court had decided that Ahmad was not the owner of the material at the time of the sale to the appellant. Since he had not the title or authority to sell the material, he could not transfer any ownership to the appellant. This means that the Ahmad is the seller, no ownership, and sold the material to appellant, and court said that Ahmad have no the title and sale invalid. And key lesson we can also the ownership or authority is essential in transferring valid title. Okay, we talk the first exception is the estoppel. Estoppel means the owners conducts the causes buyer to believe seller had authority, and also owner stopped from denying seller authority. In the case for ended security versus right car, the court held that C was successfully in claiming that A was precluded by his conduct from denying B authority to sell. Therefore, the title to the car had passes to C. This means the employer misled the buyer, that is the title passes. And we talk about the sale by mercantile agent, the second exception. Mercantile agent is the agent with usually authority. We have the condition for mercantile agent. This means they must have the good or document at in ordinary business and buyer in the good faith. And also we have the example is auctioneer, broker and commission agent.
So the third exception is sale by one of joint owners under Section 28 of the Sale of Goods Act. If one joint owner has sole possession with the other CO owner's permission and sell to a buyer who buys in good faith without knowing there no authority to sell, the buyer will get valid ownership. For example, Tom, Dick and Harry own a microwave together and Tom sold it to Nancy without permission. Since Nancy bought it in good faith, she gains valid ownership. The next exception is still under voidable contract under Section 29. This happens when a seller has goods under a voidable contract, like due to misrepresentation, but the contract has not been signed at the time of sale. If a buyer buys in good faith without knowing about the defect, the buyer will get good title. This section is important as it protects innocent buyer and keep transaction safe and smooth.
Next, sale by a seller possession after sale. Under Section 30, subsection 1, a seller who still has the goods or the documents can give good title to a new buyer even if they already sold it to someone else. What will happen to the first buyer is they will lose their right to the goods and must go after the seller for compensation. We can look at the case-specific motor auctions versus motor credits that occurred in 1965, where a car dealer had cars from the plaintiffs to sell under an agreement. He had to pay the plaintiffs when each car was sold. Then, the plaintiff stopped the dealer from selling when he had money problems. But the dealer kept selling the cars anyway. The new buyers got valid ownership, and the plaintiffs couldn't get the cars back. They had to claim their losses from the dealer. Meanwhile, the third customer already have valid ownership of the car. Next, sale by a buyer in possession. Under Section 30, subsection 2, buyer who buys or agrees to buy goods, gets possession of the goods or title documents with the seller's consent, can transfer valid ownership to someone else, which is through sale, pledge, or etc. As long as the new buyer has no knowledge of any problem with the original transaction. We can look at the case of Newtons of Wembley Ltd v. Williams that occurred in 1965. B, which is plaintiff, sold a car to A. A paid by check, and the deal said ownership would only pass once the check cleared. A took the car, but the check bounced. P cancelled the contract. A sold the car to B, who didn't know about the bad check. B then sold it to D. The court decision held that even though the check bounced, A had permission to hold the car at first. Since B thought it in good faith and had no notice of the problem, B got valid title and that title passed to D. P couldn't take the car back from D.
So, in this situation, seller bought a used car from Mina and paid the full price. However, Mina could not deliver the car because her husband, Tommy, who is the CO owner, disagreed. Under Section 28 of the Sale of Goods Act 1957, if one CO owner sell with the consent of the other and the buyer acts in good faith without knowing any restriction, the buyer can still get legal ownership. In this case, Mina had Tommy consent and Sheila had no idea about any restriction. So, all the legal conditions under Section 28 are fulfilled. That means Sheila has the right to own the car legally.
We are at the conclusion, and in conclusion, Sheila has the right and legal possession and ownership upon the car she purchased due to the exemption sale by one of joint ownership. The exemption considered successful because it completed two conditions. which is one of the owners, which is Mina, has sole possession of the car, and Sheila was not aware that Tommy is one of the joint owners.